got the slideshow?
السلام عليكم. السلام عليكم. الحمد لله رب العالمين. الحمد لله على آلائه، وأشهد أن لا إله إلا الله وحده لا شريك له في أرضه وسمائه، وأشهد أن محمدًا عبده ورسوله وخاتم أنبيائه، صلى الله عليه وآله وصحبه صلاة دائمة إلى يوم لقائه وسلم تسليما كثيرا. يا أيها الذين آمنوا اتقوا الله حق تقاته ولا تموتن إلا وأنتم مسلمون. أما بعد، سادتنا وشيوخنا الأجلاء وعلماءنا وأئمتنا وطلاب العلم إخواننا وأخواتنا، السلام عليكم ورحمة الله وبركاته. So a new session, a very blessed one, in addition to what we are studying already, regarding a very important sensitive matter, which is bankruptcy. And in that session, that we need to know the opinion of the law and the legal actions in that matter, and also the religious one. And we have these two parts. Inshallah, we'll start by the first one, which is the law system, and with the attorney and brother Yusuf Jawadi. Allah subhanahu wa ta'ala listen. Barakallah. Inshallah, for 30 minutes. Inshallah, give the presentation.
I do, yeah. Right.
From other computer.
And I emailed it to Sadiq.
If you did, it should be here.
We emailed it to him.
Let's see. Is it here?
No, we emailed it.
When?
Allah, يعني من كم دقيقة يعني.
Here he comes.
خليه يفتحها.
لابد من المسؤولين.
أنا من هيوستن والأهل من هنا.
شرفنا.
السلام عليكم. Yeah, we emailed in one for both. Yeah, هو
اوكي. ما شاء الله تحكي عربي. Hey, sorry for the delay.
Did bankruptcy in your email?
Oh, and you send me 2 PowerPoints?
Yeah.
One.
This one is defamation, and now we have a second one. On
You emailed me second one?
Yeah.
Okay, let me go grab it then. Enter, go ahead and start.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد الصادق الوعد الأمين. أما بعد, today we're going to dedicate 30 minutes to discussing bankruptcy law as it is in the United States. And while he gets the PowerPoint, I'll give you a brief introduction. Now, just like we discussed with defamation, there's state law and federal law, right? But with bankruptcy, there is no state law and it's all federal law. Okay, so I'm going to say that again. There is no state law in bankruptcy. Bankruptcy is only federal law. And there is about 5 different types of bankruptcy. And we're only going to look at 2 types. The first one, Chapter 7 bankruptcy. And the second type is Chapter 11 bankruptcy. Okay, Chapter 7 is usually done by a person, a private individual. And Chapter 11 is done with an organization or a business. So if we define bankruptcy, it is a federal process that can help you eliminate or restructure your financial obligations. Okay. The Federal Bankruptcy Code was written by Congress, and the laws are interpreted by the federal courts. So the code, just like you have the family code, just like you have the estates code, just like you have the penal code, the criminal code, we're going to have something here called the Federal Bankruptcy Code, and this is what governs all of bankruptcy law, the Bankruptcy Code. And as we said, the cases go to the federal district courts. Now, the purpose of bankruptcy pretty much enables you to have a fresh start button. So if you want a reset on your financial status, you can go into bankruptcy proceeding. Now, it gives to the honest but unfortunate debtor a new opportunity in life and a clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. And it also gives fair and equal treatment to creditors who are owed money. And so this is the goal of bankruptcy, to sort of provide a fresh start to those who need it, whether it be a person or it be an organization. So if we start with Chapter 7, Chapter 7's title is liquidation. And so what this means is you have a house, you have a car, you have a business, you're going to sell all of that and it becomes liquid. And that way you have cash and you can pay off all of your debts. So this is what Chapter 7 is. It enables you to liquidize all of your assets and then pay off your debts. Is it working now? Or? This is HDMI, right? So anyways, that's Chapter 7 bankruptcy. I think it's working here. We'll continue, inshallah. Now, continuing on Chapter 7, when you have a bankruptcy proceeding, a trustee is appointed. And because at first, a temporary trustee is appointed, and then a permanent trustee is appointed. So maybe you have like 5? Like that? It works? Not there. Okay.
And the clicker should have here.
Let's do this. Alhamdulillah, the PowerPoint is working. So as we said, today we're going to be looking at bankruptcy law. We defined it. It is a way to eliminate your financial obligations. And it is in federal court. It's not in state court. Now, the federal courts are the ones who interpret the laws on the bankruptcy, and it enables you to sort of have a reset button on your assets. Now, the first one, as we said, there's 5 types of bankruptcy, 5 or 6. We're only going to be looking at 2, Chapter 7, Chapter 11. Now we're at Chapter 7, liquidation. And this is the one that an individual uses when it comes to filing bankruptcy. So moving along, we said a trustee is appointed. When you file for bankruptcy, you don't have control over your assets. You can't sell your business, and you can't sell your car, etc. The trustee does this. He or she is appointed by the court to sell and manage your assets. Now, an interim trustee is first appointed. You just filed for bankruptcy. They don't have time to appoint a permanent trustee, so they're just going to put a temporary trustee at first, an interim trustee. Now, after that's taken care of, he sort of takes title to everything. Then a trustee is appointed at the first meeting of creditors, and if none is selected, the temporary trustee continues, right? He continues to manage the assets. Now, the duty of a trustee is to collect, sell, and reduce to cash the assets of the estate. So the trustee sells and makes everything into cash. Moving along, he also makes a final report at the end. So, now let's say the trustee sells everything and you have a lot of cash sitting there in the court registry. Who gets what? What's the order? You have 2 liens on a house. I mean, which one's going to get paid first? That's a legit question. So, what we do is we look at the ranking. And so, the first in time, there's different types of loans, and usually certain loans get priority over other ones. Your house loan is going to have more of a priority than your credit card debt if your house loan was acquired before the credit card debt. So if you were first in time, that person will have priority over later creditors. Okay? So the first one is priority claims according to the rank. Secondly, unsecured claims filed within 70 days of the proceeding. So if there's a credit card company out there that has a claim against somebody who has debt, they have 70 days to file in the bankruptcy proceeding. And so they better do that or they're going to lose priority. Other people will get paid before them. Well, very important here, we have an order of distribution. And then we have unsecured claims that were filed late, and claims for fines, penalties, forfeitures, or punitive damages. So if you have a lawsuit against you with punitive damages, then those need to be paid fourth in line. Fifth, claims for interest that accrue after a petition is filed. So those get paid. And lastly, after everything is paid out, the debtor gets everything else. So the person who was in debt, after everyone gets paid, he gets the rest. The surplus. Now, so what are the priority claims? If you look here, the first one was just priority claims. So what is this? There is actually 10 subcategories in that first one right there. 10. So we look at the first one. If you have child support, these must be paid first. Do we need to talk in Arabic?
That's okay.
Okay. All right. So we have child support obligations, or you have spousal maintenance or anything like that. That's number one. This gets top priority. And by the way, this is the same when it comes to when someone passes away and he has child support, debts like that. The second priority is expenses of the bankruptcy proceeding. So subhanAllah, you're not going to run away from paying the bankruptcy court itself. That's number two. Okay, yani, they're going to take your money, yani, whether you like it or not, from the proceeding itself. Yeah, that's why they're helping you, yani. They put a trustee for you. The trustee is going to get paid. In the case, the court's going to get paid with the court fees and the lawyers, of course. Third priority, we have involuntary gap claims, which is claims that accrue in the ordinary course of business after an involuntary petition is filed, but before the appointment of a trustee. So there's some debts between the filing of the petition and before the trustee is appointed. These have third priority. And then fourth priority is wage claims. So employees who have claims for wages. Say you have a business and you have employees and they're requesting their pay. SubhanAllah, you have to pay them their wages. Employees who have a claim within 180 days before the filing of the petition can do so. Continuing along, we have the fifth in line, contributions to employee benefit plans. So if you have an employee who has a benefit plan, these 401ks and such things, those need to be paid. Unpaid contributions to employee benefit plans, such as health insurance, pension plans. You can't run away from paying your employees' health insurance when it comes to bankruptcy. So, like we said, they're in order of priority. And sixth in line is claims for grain or the proceeds thereof by persons engaged in the production or raising of grain against a debtor who owns or operates a grain storage facility. So this is pretty much applies to farmers and the like. And seventh in priority, claims arising from the pre-petition deposit of money with the debtor for the purchase or lease of property. So that has a space in priority as well, the purchasing and leasing of property, but up to 2850.
Can you say it in Arabic, number 7?
Number 7. 7. Okay. Claims arising from the pre-petition deposits of money with the
ولو باختصار
يعني إذا واحد عم بيأجر بيت لازم عم نحكي هلا باللبناني بصح Lebanese Arabic, yeah. I can speak the formal, but a little more difficult. يعني إذا واحد عم بيأجر بيت وله دين فيها لازم يدفع يعني up to $2,850 بالرنت يعني بالأجار. أجارة البيت نعم. هلا. Eighth in priority, tax claims. If you have anything with the IRS, these are eighth in priority. Ninth in priority, capital requirements of insured depository institution and personal injury claims resulting from intoxicated operation of a vehicle. So if you're in a car accident and someone sued you, you were, like say this is a non-Muslim who was drinking and then got in a car accident and there's a claim against him because he was drunk driving, this is 10th in priority. So subhanAllah, they're going to milk you dry before you get anything or when you do a bankruptcy proceeding. So be very careful. Everyone's going to get their haqq for the most part. So this is only, if we go back, this is only the first one, priority claims. And then we have unsecured claims and claims for penalties and interest. And then, and lastly, the rest is distributed to the debtor. Now, so that was chapter 7. Chapter 7 is where you sell everything and you're left with nothing. And you just pay everybody and you're back to a fresh start. But however, chapter 11 applies only to a business who wants to reorganize. So say you have a business that's like a grocery store and you're in debt and you need to reorganize and you don't want to do chapter 7 and sell everything. A business can do chapter 7, but they will have to wind up the business. They'll have to terminate the business and no more business. That's it. But with chapter 11, you have 60 days to fix your stuff and then restart. And the court approves your plan. You make like a plan to restart. Now, so who's eligible? Only corporations, partnerships, and individuals, and it is commenced by filing of a Chapter 11 petition for relief. So the way we start these is you go to a lawyer and you tell them, hey, I want to file Chapter 11 or Chapter 7, and we file the petition for you. Now, filing must include a list of the 20 largest unsecured creditors, so you got to say who you owe money to, the top 20, a list of the debtor's equity security holders, a complete list of all creditors, and creditors do not have to file proofs of claim unless the debt is disputed, contingent, or unliquidated. So, continuing, a debtor, now we're talking about continued operation of the business. Do you remember when we said in Chapter 7, a trustee is appointed to take over your stuff and sell them? Right? In Chapter 11, this is not the case. In Chapter 11, a trustee is usually not appointed. You are allowed to reorganize your stuff according to how you want. Okay. Rather, the debtor remains in possession of his assets and generally has the same powers as the trustee. So a trustee can be appointed if you apply. The courts apply. If you want a trustee to take over your stuff, you can do it. But remember, that's going to cost money, and who's going to pay it? You. So whenever a lawyer is appointed by the courts or a trustee, I mean, the proceeding itself usually pays for that. Usually. They're not going to pay it for you. Now, a trustee can be appointed for cause if there is mismanagement, or if we see the person is dishonest and there's fraud and there's dishonesty and incompetence, then that's when the court's going to appoint a trustee in a Chapter 11 bankruptcy case. Everything clear so far? Alhamdulillah. Let's move along. So we have a plan for reorganization. Who can file this? A debtor is given the exclusive right to file a plan of reorganization for 120 days after the entry of the order for relief. So you have 120 days to file a plan of reorganization. Now, the requirements of the plan are the following. You must designate classes of claims and interests. You must specify any class of claims that is not impaired, specify the treatment of the classes, and provide equal treatment for each member of a particular class. So pretty much, if you want to do Chapter 11, you get with your lawyer and you got to do a plan of reorganization. That's the bottom line. And it's going to be very detailed, and it has statutory requirements according to federal law, the Bankruptcy Code, and you compile it. You have to provide adequate means for implementation of the plan. So you're telling the court, all right, I'm going to fix my act up. I'm going to get my act together, and this is how I'm going to do it. You got to tell them how. I'm going to stick to my grocery store. I'm going to eliminate that restaurant that I have attached to the side. It's not really working out. I don't know why I did that in the first place. I'm going to sell that piece, and I'm going to stick to the grocery store, for example. So you have to provide adequate means for implementation of the plan, such as merger or consolidation. You might want to add shareholders. You want to pay off some debts here and then get a few other shareholders involved. Satisfaction or modification of liens, and cancellation or modification of any indenture or similar instruments. And it must pass the best interest of the creditor's test. So whatever you have in this plan of yours has to pass a test. Okay, it has to pass a test. And that test is called the best interest of the creditor's test. Okay? Well, for example, if there's a divorce, then any decision that is passed in the family court has to pass the best interest of the child test. It has to be in the best interest of the child. And this is the same thing here, but it's a bankruptcy case. It has to pass the best interest of the creditor's test. And that has factors you have to satisfy. So you're going to have to get that plan to the court once you finish drafting it. We're going to show it to the judge. And then if he sees that it satisfies all of the appropriate classes and requirements, then the court approves it. And once the court approves it, the confirmation will vest title to all property in the estate of the debtor. And it binds the debtor and all creditors to the terms of the plan and discharges all debts dischargeable under the code. So once the judge signs your plan under the Chapter 11 bankruptcy proceeding, it's binding. You got to be careful. Once the judge signs that, it binds the debtor and all creditors to the terms of the plan. So every single sentence in that report is very important, and you want to be careful what you write in there and what you don't mention in there, actually. And so with that, that's the end of my presentation. It's about 20-25 minutes. And I guess we'll pass it on, or if we have any questions, or how's the structure here.
Thank you very much, Brother Yusuf.
Okay, Assalamu alaikum wa rahmatullah.
And the mercy prevail all the world, not only Yemen, all the Muslims all over the world, inshallah. Barakallah fiqh, jazakumullah khairan. It's a great honor for us all to help and support you. Allah subhanahu wa ta'ala bless you. Inshallah now, نواصل الشق الشرعي لمسألة البنكربسي إن شاء الله مع شيخنا الدكتور معنا. تفضل. شكرا.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين. اللهم صل وسلم وبارك على محمد وعلى آله وصحبه أجمعين. ثم أما بعد. أتدرون من المفلس؟ أتدرون من المفلس؟ المفلس فينا من لا درهم له ولا متاع. وحديثي إليكم أحبتي عن الإفلاس، لكن عن الشق القانوني الحقيقة، وليس عن تعريف سيدنا صلى الله عليه وسلم الإفلاس عندما قال مفلس من أمتي من يأتي يوم القيامة بصلاة وصيام وحج وزكاة ويأتي وقد الحديث الذي يعني تعرفونه جميعا. لكن الحديث الحقيقة عن معرفة الصحابة للإفلاس عندما قالوا المفلس فينا من لا درهم له ولا متاع. So I'll be talking briefly about bankruptcy. Before discussing the fiqh part of it, or the fiqh portion of it, it's good just to review briefly some of the legal terms and definitions that we have gone through with Attorney Yusuf. Jazakallah khairan. Am I correct? Your name is Yusuf? No, Attorney Yusuf. So briefly, when we say bankruptcy, so and so individual applied for bankruptcy. Now put all these details aside, Chapter 7, Chapter 9, Chapter 11, regardless of all these details. When we say bankruptcy or someone applied for bankruptcy, bankruptcy is the legal status of a person or other entity that cannot repay the debts it owes to creditors. Someone feels with a corporate, individual or actual individual, feels that he or she is financially unable to proceed with his financial commitment. That's why he wants to declare bankruptcy or to be declared as a bankrupt by the court. Bankruptcy is imposed by a court order, often initiated by the debtor. So you are the one who's supposed to initiate the request to the court through your attorney and apply for bankruptcy. Another term that we'll be using a lot here, which is a discharge. What does it mean in this context when you say discharge? Discharge in bankruptcy refers to a permanent order that releases the debtor from personal liability for certain specified types of debts. So whenever you are discharged by the court, it means that you are not liable or not obligated anymore to pay off the debt. Even in the future, you became financially solvent or able to pay it, you are not expected or you're not supposed to pay it, because legally speaking you are discharged. So for a certain specified types of debts, thereby releasing the debtor from any legal obligation to pay any discharged debts. That is when we say discharge in this particular context. After a bankruptcy is discharged, the debtor will no longer be legally responsible to pay off the debts. When we say no longer, actually it is literally no longer. Even in the future you became financially able, you are not supposed to go, and pay off the debts that you owed in the past. Even when we discuss the bankruptcy, there is always an option to keep paying, which means that if you decide under certain chapter of those 5 different chapters that Attorney Yusuf referred to, you can still continue proceeding with certain debts. For example, you have your own business, you have your own house, you have your own car, and you feel that you are still financially able to pay off the monthly payment for your car, for example. Can you, legally speaking, can you do it? The answer actually is yes. Under certain category, of course, you need to consult with your attorney, but you can, for example, declare bankruptcy through the court, okay, and you will be waived from paying off the loan of your house, for example, or your business, for example, but you still can actually, commit to paying off the debt of your car in our example. So if the debtor wants to continue paying a particular debt to preserve an asset from being liquidated, okay, or like taken or seized by the court system, such as a house, for example, car or furniture, he may continue to do so, and the contract between the two parties is not affected by the bankruptcy. Of course, this is, should be done through your attorney under certain, level or certain category of bankruptcy. What we care about in this presentation actually is the Islamic perspective. Where do we stand when it comes to bankruptcy? Number one, for us as Muslims, the concept actually of integrity and honesty is essential, because in the real life, you are able to hide or to keep certain assets undocumented. Okay, you put something aside, you do not report to the IRS. I'm not saying that this is legal. I'm saying, this is what we experience in the real life. Sometimes you report some assets or some properties, and sometimes you do not. So the very first thing to emphasize here is that you are not allowed Islamically. Okay, that's between you and Allah subhanahu wa ta'ala. بينك وبين ربك عز وجل ديانة. You cannot, you should not, you are not supposed to apply for bankruptcy unless you are 100% positive that the current properties and assets and estate that you have are insufficient to commit to paying off your loan. If you think that you can manage in a way or another, okay, or you expect maybe some profit or some assets that are coming soon, and based on that you are able, you will continue, you will cope with paying off the debts that you have, then you are not supposed to apply for bankruptcy. This is what I mean by the concept of integrity and honesty. So it is forbidden for a Muslim to make such a decision unless the claim is true and genuine. Again, the IRS cannot go after you if there is a property that is not even documented to start with, and you are the only one who knows exactly what do you have and what you do not have. Some of the properties are documented and some of them are undocumented. You know very well what is documented, what is undocumented. So he must ascertain that all of his current possessions are insufficient to pay off the debts, and that most probably he won't be able to pay them off later on. Why later on? Because again, once you are discharged, then you are permanently waived. You are permanently waived from paying off your debt, even if you are financially able or you became solvent later on, you are still actually not required to pay off any debt. Let's differentiate here between personal and religious liability. Okay? سقوط الحقوق ديانة وسقوطها قضاء. What's the difference? You might get a decree by the judge that you're good to go. You are waived, you do not have to pay for your house, for example, okay? Or for a certain individual that you have borrowed money with. Now, does this mean that if you are legally waived, religiously between you and Allah subhanahu wa ta'ala still waived? The answer is no. There is no connection between the two. لأن قضاء القاضي لا يحل حراما ولا يحرم حلالا. So if a court order discharges a debtor from personal liability or legal liability, you're good to go. You do not have to pay off the loan. That is the personal or the legal liability for a debt. while creditors have received their money from different resources, he is also released from his religious liability. إذا سقط الدين قضاء وحصل الدائنون على أموالهم. That's something new. وحصل الدائنون على أموالهم فقد سقط الدين ديانة بينك وبين ربك عز وجل. إذا سقط الدين قضاء وحصل الدائن على ماله من جهة أخرى فقد سقط الدين ديانة. كل دين سقط قضاء فقد سقط ديانة إذا حصل الدائن على ماله. Because the main reason behind going after you, religiously speaking, diyanatan, is to make sure that the creditors actually are getting their money back. So by any chance, by any way, by any system, if you are 100% positive that the creditors, for example, already got their money. I'll give you an example. You have a credit card and you have outstanding balance. For some reason you applied for bankruptcy and all the $25,000 had been waived. You do not have to pay off the credit card company $25,000. If you are positive 100% for sure that the system here in the US works in a way that those companies actually do have insurance against bad debts, and you are positive that the $25,000, once you are declared bankrupt, then the credit card company will be getting its money from the insurance company. Then there is no point behind obligating you to pay off that debt again. Even accounting wise, it does not work, because actually the whole debt is already waived. Okay, you owe the credit card company $25,000. They got their money because you already have been declared as bankrupt. 10 years later, okay, you became able to pay them off. You are not supposed to go and approach that credit card company and try even to pay them the debt, because you already have been waived and they already have been, gotten their money from the insurance company. So this is actually what I mean by whenever a debt, okay, one more time. If a court order discharges a debtor from a personal liability or legal liability for a debt, while creditors have received their money from a different resource, that is actually the challenge that you face here. You have to make sure that creditors already got their money. If that is the case, then you are still released from your religious liability. ديانة بينك وبين ربك عز وجل. It is noteworthy that, bankruptcy wipes out only some debts. There are a number of debts that are unaffected by bankruptcy. Again, let's say for example that you owe the credit card company $25,000 and you have borrowed from XYZ individual $25,000, just to keep it simple. And then later on you have been declared bankrupt by the court. Okay? The credit card company got their money, and to my knowledge, insurance companies do not issue any insurance policy against any personal debt. So that XYZ creditor cannot get an insurance, because he has lended you $25,000. So there is no way for him to get his money. If that is the case, and you have been waived from paying the credit card company, later on you became solvent, financially able to pay the $25,000 to XYZ individual, do you have to pay him off or not? Of course you have to, even if you have been waived or discharged by the court. لأن قضاء القاضي لا يحرم حلالا ولا يحل حراما. And we are very, very positive that the creditor, the individual, the XYZ individual, did not get his money. You might be waived for the time being because of your financial difficulties, where Allah subhanahu wa ta'ala indicated in the Quran, وإن كان ذو عسرة فنظرة إلى ميسرة. If that person actually is insolvent, then the creditor should give him, more time to be able to pay off the debt. Institutions versus individual creditors. I think this is the same point that I just emphasized. In order for a debt to be removed by bankruptcy, the creditor must be an institution or entity. If it is an individual or a group that gave a personal loan, that debt will not be affected by the bankruptcy. Consequently, whenever you are able to pay it off, then you have to pay it off. I have noticed from Attorney Yusuf's speech that there is a kind of integration between bankruptcy as a concept and interdiction or al-hajr. When he was talking about chapter 7, he said that you will not be able to execute or to liquidate the properties, rather the court or the judge will be assigning a trustee. And that's the exact concept of interdiction in the fiqh al-Islami, which is al-hajr. Al-hajr, you cannot make any financial decision, rather somebody else actually will be deciding in your behalf. So this particular concept actually has to have like further study like regarding the fiqh rules of interdiction versus bankruptcy. I'm not aware of it. I need to do more research on it, inshallah. How the system works: creditors, whether banks or mortgage companies or credit card companies, have insurance on their loans. Most probably it is the case. 99.9% those like companies do have insurance policy against any bad or unpaid debt. So they will be getting their money. Do not worry. Companies that lose money, to a debtor declaring bankruptcy, collect the amount from the insurance companies. Again, always have in mind that the seriousness in the hadith of the Prophet ﷺ, that huquq al-ibad are not to be waived. There is a point behind it. We have to make sure that the creditor or the one actually whom you owe is getting his money. That's the whole point. Well, if he or she can get his money from a third party, and that is actually the prevailing practice, that is the system in the US. Again, there is no point behind obligating you to repay that debt one more time. It makes no sense whatsoever. Again, remember the credit card company issue. $25,000 has been taken care of. Even after 10 years, if you are able to pay them, there is no point behind you being obligated paying them back because they got their money already. Something else that is very relevant here, which is death versus bankruptcy. Maybe during the question and answer session, I will ask Attorney Yusuf regarding this point. But to my knowledge, I'm not that specialized in this field, that death actually takes the same rule of bankruptcy. If someone owes a credit card company, for example, and he passed away, then that person actually is waived from paying off the debt. So death takes the ruling of bankruptcy. Now, from a fiqh perspective, which is my field here, if the debtor passes away and released from legal liability, that person is already dead. I mean, you cannot go after him, ask him to pay debts. So if he is waived from legal liability, while creditors have received their money from different resources, then he is also released from the religious liability. Sallu ala akhikum, hadith al-Nabi alayhi salatu wasalam, the one who passed away while owing others, actually emphasizes the exact point, because the creditors did not get their money. And when someone of the Sahaba guaranteed the loan, Prophet ﷺ decided to lead Salatul Janazah. Well, the insurance company nowadays is guaranteeing the debt of the dead person. So again, no point behind obligating inheritors to pay off on behalf of their deceased. Individual creditors, if the creditor is an individual, neither declaring bankruptcy nor the death of the debtor would wipe out the debt. Again, that is the system in the US. Insurance companies do not issue insurance policy against individual loans. You have to be a credit card company, you have to be a bank, you have to be a mortgage company to get an insurance against bad debts. And having said that, insurance companies do not offer individuals coverage for the debts they are owed. So, whenever a debtor is able to pay the debt, then he has to, according to the ayah, وَإِنْ كَانَ ذُو عُسْرَةٍ فَنَظِرَةٌ إِلَى مَيْسَرٍ. Something that is very, very relevant here, which is the statute of limitation. That's a US law. Statute of limitation means that there is a certain period of time, if the creditor does not go after the debtor and ask for his money to be paid back, then the right actually will be expired. Okay, the individual right, the legal right will be expired. That's the meaning of statute of limitation. So it is a law passed by legislative bodies in common law, اللي هو القانون السوابق القضائي, common law system, to set the maximum time after an event within which legal proceeding may be initiated. Okay, someone did not pay you on time, and you waited, for example, for 10 consecutive years. You did not even bring it to the attention of the court that so and so individual did not pay me. Okay, can you just wake up after 10 years وَالذَّكَرَ بَعْدَ أُمَّةٍ and you start applying for that? Well, the judge actually will be saying, oh, statute of limitation, there is no right for you. I mean, your right has been expired. Now the question here, do we believe in the fiqh al-Islami? Do we believe in the statute of limitation? Does it apply? It does not apply. حقوق العباد لا تسقط بالتقادم. حقوق العباد لا تسقط بالتقادم. As simple as that. Okay, you borrowed money after 10, 15, 20, 30, 40 years, whatever the period or the duration might be, there is no way for that right to be expired. So statute of limitation actually is a non-Islamic concept, and we in the fiqh al-Islami do not believe in it. And finally, قضاء القاضي لا يحل حراما ولا يحرم حلالا. If you have been discharged from a personal loan by the judge, if you are financially able to pay off the loan, you have to pay it immediately, and your religious liability will never ever be released in front of Allah subhanahu wa ta'ala. And if you cannot for the time being, then you are still owing that individual that amount. Whenever you are able to, then you have to pay off that loan, because that individual did not and will not get his money back through the insurance companies. وَإِنْ كَانَ ذُو عُسْرَةٍ فَنَظِرَةٌ إِلَى مَيْسَرَةٍ. So this is briefly what I have in mind regarding bankruptcy. Of course, you have to set your priorities in paying the loans. Okay, let's say, for example, that after 5 or 10 years, okay, you recovered financially and you became, solvent, like able to pay off. Of course, you need to start with individual loans that were not paid off on your behalf by the insurance company. Then after that, if you are positive 100% that a certain company, okay, credit card, mortgage, whatever, did not get paid by a way or another, and you are financially able to pay off, then actually you are still liable in front of Allah subhanahu wa ta'ala to pay off that loan. This is briefly what I have. Sallallahu ala Muhammadin wa ala alihi wa sahbihi ajma'in.
بارك الله فيك دكتور معنا، جزاك الله خير. الآن مع أستاذنا الفاضل شيخنا الكبير الشيخ صلاح.
خذ ما شئت.
بصراحة بيخاف من حتة.
تطلع القنابل بس.
من حتة.
بارك الله. اللهم اهدنا سواء السبيل يا رب، قنا عذابك يوم تبعث عبادك.
السلام عليكم ورحمة الله وبركاته. الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه. استمتعتم بالحديث فضيلة الشيخ معنا باللغة الإنجليزية وقد طوف بكم في آفاق القانونية.
Dr. Mann spoke about the legal matters related to bankruptcy.
باللغة العربية
And this is the Arabic portion of this matter. Bankruptcy, from a worldly perspective, is you being asked to pay more than what you have presently, more debts than the property they have presently.
ويشترط أن تكون الدين
And
حالة.
the condition is that the debts are due now. Later debts are not included in bankruptcy.
وعلى أساسه يقوم الشخص أنه
Bankruptcy was based
أو
on debts that are due now. That's how we define bankruptcy. They have more debts due now than what you have. This is the majority. It's a majority opinion,
الإفلاس والتفليس.
and the Malikis differ on this.
الإفلاس الحالة لشخص موجود في حالة زادت.
So a person who is bankrupt is what we mentioned.
التفليس في الحكم القضائي الذي
And then we have, that's the state, this is the state of a person being in bankruptcy. Then we have the judge ruling bankruptcy. The judge will rule that this person is bankrupt. When the court gets involved, this makes him pay it off. It makes him stay away from engaging in other business transactions and so on.
في مفهوم آخر فقهي اسمه الإعسار.
There's also another legal term called ihsan, which is a description of someone being into dire straits, dire financial straits. Someone who is in a tough financial position where he doesn't have enough to eat or drink or pay his daily expenses. So it's different than someone who is bankrupt. Bankrupt, someone who can't pay his debts. But ihsan is someone who's tight in cash, someone who can't pay his daily expenses.
ما عليه من ديون والمفلس هو من التصنع أبرز الفروق.
The biggest differences between someone who's dire straits and someone who's bankrupt. It's that someone who's in dire straits. It could be before. He could have had a lot of money before or not. But the one who's bankrupt must have had money before, like a businessman. Someone who's a big tradesman and paid people's debts off and everything. All of a sudden, economic times, or his property is destroyed or something. So that's his bankrupt. So someone who's bankrupt, he must have had money before. As for someone who's in dire straits, he could have had money before, or he may not have had money before. As for Hajr, someone who's prevented from engaging in business transactions, a judge rules upon someone that he's Hajr, that the person cannot engage in business transactions after we declare he is bankrupt. So we don't want anything from that individual. We want his money. Well, he doesn't have money, so what do? We have to wait until he can pay it off, and then we limit his transactions so he doesn't waste any more money until he can pay it off. So the judge can put a person who's bankrupt who will not pay. He can put him in prison as a punishment. As for someone who is in dire straits, no, the person is not put in prison by a judge. So,
دين النفقة يا الدفع يا الحبس. دين النفقة إما الدفع وإما الحبس.
Being in dire straits includes religious obligations such as spending on your family. If you can't spend on your family. As for bankruptcy, bankruptcy is only related to financial business matters, not personal obligations like having to pay your family spending money. And we have different types of bankruptcy. So we have someone who is bankrupt and was successful. All of a sudden, he was afflicted with economic problems, natural disasters. His factory was burned down, and so he was affected by this and became bankrupt. We have other types of bankrupts, which is someone who it's not that things outside of his control, but he himself is not organized. He's not a good businessman. He gets into trades that are risky. He's someone who is he's not smart about what he does. He's irresponsible to what he does. So he's kind of careless, he's not organized, so then he becomes bankrupt. So we have someone who's bankrupt because of something out of his control, and we have someone who's bankrupt because of his own doing.
النوع الثاني والثالث الاحتيالي والتقصيري ده مصنف ضمن جرائم الإفلاس ويلاحق قانونا
And these types of bankruptcies there are laws and punishments related to them.
آثار التفليس
The effects of bankruptcy. Number one, the one who owes money, we prevent him from dealing with his wealth, trading and buying and selling. And his debts that are not due yet, we say that he has to pay them off. The Amja Council decided that a person who is in dire straits or bankrupt, they wrote a paper on this, on the effects of it. So Amja decided that a person is bankrupt, even though this goes against the majority, but they said that your delayed debts should now be considered present debts they have to pay. Especially especially if that due to bankruptcy, this company is going to dissolve. So how are the people who have debts that are owed later on going to get their money if you don't have any company anymore to work for? So once a person's bankrupt, the Amja chose the opinion that your delayed debts have now become present, so you have to pay them now because your company is going to get dissolved, and so you don't have another means to pay them off later on. So we're going to make you pay them now. As for the rulings of restricting someone's economic abilities, if we go back to those rulings, it revolves preventing him from doing any sort of action, economic action, financial action that would harm the people that he owes money to. Also, it could include preventing him from traveling, for example, making him pay all advanced debts now, and the judge can make him pay his property to pay off the people who owes money to the creditors. The right of the creditor. He has the right to get his wealth back. His debt that is present amongst the property, his property. He has the right to get his property that he's owed if it exists amongst the property of the debtor. Someone sold you a car. He has the car with him, and he became bankrupt. He has the right, the creditor has the right to go get that car because it's his. So if someone is owed property and it exists amongst the property of the debtor, the one in debt, the creditor has the right to go get it. So after this declares bankruptcy, what is left for the one in debt? And we freeze his assets, right? We freeze his assets and so on. What do? We restrict his access. But what's left for him? We leave for him only the things that he needs, like clothes, books, the house, right? His bed, his car, his tools, his necessary books, and everything that's extra than the things that he needs, then we sell it. We have two imams. They say that his house, we should sell his house, and then we can rent a smaller apartment. Someone who's bankrupt, we can sell his big house, and then we can get a small apartment to rent, like a American Cafe. Similarly, the car. Someone has a very nice car, $500,000, and became bankrupt. He should sell the car, use the rest of the money to pay, and get a regular car for him. So he should not live a life of luxury while he's bankrupt, at the expense of the creditors. What about after we declared bankruptcy and we sold his property, there are people who still didn't get their money? What do? He didn't pay off all his debts. What about the creditors that didn't get their money? What do? the right has not been dropped. Either you pay it off or he frees you from that obligation.
لكن النظر يقول
So,
بحقوق الشركات والشخصيات المعنوية
what do we do?
اللي ممكن يتصور انها تؤدى من جهة أخرى.
Maybe there's another legal way to get it paid through a third party. So I'm going to continue researching with the lawyers to see if there's a third legal party that can get us a source to pay off these debts.
تعاملي مع شركة التأمين
He said me dealing with insurance companies, I pay them money. And then when they pay me for an accident or something, regardless of whether insurance is halal or haram right now, but when I work with the insurance company, I pay them money and then they pay me back for occurrence. However, if the money was given to the insurance company through a third party, through a government giving him gifts, for example, then we can understand that. But I'm paying money from my pocket. So when the insurance company gives me money, that's due to the payments I paid. I didn't give the insurance company didn't give me money for free. So we want to apply this to bankruptcy. That we have to pay the people's payments because they paid money for their rights in return. And we don't want to find ways that people can get to escape from their rights, trying to find a third party to pay for them so they don't have to pay. We have to remind them about the punishment mentioned in Sharia about someone who takes people's wealth and doesn't give it back to them. People who are in debt, there are texts in the Sharia that are very severe about the one who had debts. The person would not pay the funeral prayer who was in debt. And so two people had debts. So one Sahaba took care of one of his debts. So the Prophet prayed upon that one person. 2 days later, and he told the companion, did you pay off his debt? He's not yet. And so then he asked him again, did you pay off his debt? So then he paid off his debt finally. So playing with laws and resorting to laws to try to get a third party to pay off people's debts instead of you paying your debt will get people from being careless about paying other people's, taking care of others' rights. And tomorrow, so right now is a time of action, and tomorrow will be a day of recompense. And of course the one who is truly bankrupt is the one who comes on the day of judgment with no good deeds from his actions.
Inshallah, we will start now the questions and answer session. Inshallah, the same rules apply. Inshallah, from the right for the brother, from the left to the brothers, and then the sisters. Barakallahu fikum. تفضل inshallah. تفضل. عليكم السلام.
It's okay. Can I speak loud, inshallah?
تفضل يا دكتور عبد.
So
تفضل. طيب, Attorney Yusuf will just give a comment in 2 minutes.
Assalamu alaikum wa rahmatullahi wa barakatuh. Just a couple of follow-up points were brought to my attention by Sheikh Salah Sawi. Now, we talked about the Chapter 7, discharging your debt. However, not everything is discharged. There's non-dischargeable debt. And this is going to be in the federal law, 11 U.S.C. 523, exceptions to discharge. And subhanAllah, in the law there's always exceptions. And there's exceptions to the exceptions. and there's exceptions to the exceptions to the exceptions. And this is what they teach us in law school, subhanAllah. Anyways, the first exception, fail if you don't put it in the petition. If you don't put it in the petition, you forgot to mention it, they still got you. So the second one, some taxes. Third one, spousal and child support. So that's very important. Also student loans. Student loans cannot be forgiven. Also, if there's a case against you for personal injury damages and because you were a drunk driver, those cannot be forgiven. And attorney's fees in child support cases. I like this one. يعني مال المحامي. Yeah. So, see, the lawyers write the law, so we're going to write it in our benefit. يعني. And also court fines. So these are some, not all, only some that are in the law. Not exclusive, no guarantees. So, second thing, he mentioned, Sheikh Ma'in mentioned in case of death. So this is actually my specialty when, especially doing the Islamic wills and doing all this stuff previous to death, and also my specialty after death, what happens. Now, after death, different rules apply. It's going to be the Texas Estates Code. Like you have the Family Code, you have the Criminal Code, you have the Estates Code. And in section about 353, there is a list of priority, who gets what, and the debts depend on the type of debt. If it's secured or unsecured. If it's secured, it means you have security, you have a house. If you don't pay, they take the house. If you don't pay, they take the car. These ones, they have around, I'm not going to say exact, I have to take a look again, but it's around 60 days after the executor is appointed to have a claim and claim that debt. If the creditor forgets, then the debt is no longer valid. Can you believe that? After dying and you go to the courthouse to appoint the person to manage your stuff, if after 60 days the secured creditor does not raise a claim, they lose the debt. Yes, statute of limitations, you can call it that. And actually, you know how they have I'm sorry for your loss letters? I'm sorry for your loss. Now, I call these I'm sorry for your loss letters to them. I write them a letter, I'm sorry for your loss. You lost your claim for the debt. So that's a couple of important points. The first rank when someone dies is going to be the funeral expenses, burial expenses. Then it's going to be child support, and then secured and unsecured claims. Unsecured is the bottom, which is like credit cards and stuff like that, medical bills. It's not attached to a security. Okay. So there's a different list in section 353 of the Texas Estates Code, and we can chat afterwards if you want to talk about any of this inheritance stuff. And that's my comments for now. Assalamu alaikum.
Starting with the question, Sheikh.
السلام عليكم. السؤال الأول اللي فضيلة الدكتور صلاح، أنا الحقيقة كان عندي سؤالان لكن السؤال الأول فضيلة الدكتور صلاح، هل ترى ينطبق نفس الحال على ما ذكرتم على بقاء الديون في ذمة الميت أو في ذمة الإنسان حتى مع الديون التي للحكومات أو للهيئات؟
The rules that you mentioned, these debts like ER debts for like $16,000 and the ER and so on, just because they gave him a little bit of medicine, that's it. And so they overboard with these debts. So can you declare bankruptcy to get out of these like outstanding, extremely unreasonable debts?
فهل هذا يلزمني إذا هم أصروا على إنك عندك أو عليك لنا 10,000 مثلا، هل أطالب بهذا في الآخرة؟
Would I be responsible in the next life?
وإذا سمحت لي فضيلتك أذكر السؤال الآخر، هذا الدكتور معا ثم أنصرف السؤال الآخر.
Next question.
الديون الطبية
Medical debts, we have to discuss it with the doctors
حتى ينورونا بهذا.
so they can enlighten us.
لأن المبالغة
Because
جدا جدا.
it's true that
الإذعان
you are forced to pay unreasonable prices and debts.
ولا تملك
This is what the hospital said, and you have no other option. You go to collections agents, and there's nothing you can do. You can try to bring it down, but we have to discuss it with the doctors. We have to do a communal ijtihad with the scholars,
وأطباء عشان نوصل لفورمولا
so we can get to a formula that works. And it's not that this is oppressive, and they do have some rights because they gave you a service, but there's no doubt that they overdo it.
ساعات أو أيام أو كذا هذا يشبه حقا يقينا. أما تقديرهم للحق مبالغ جدا فيه فأنا أعتقد أن الموضوع صعب يفتي فيه.
So right now it'll be difficult to give fatwa on it. We need to meet with doctors and get the correct formula for this. Either we get a general formula that works for everyone, or we can talk about a specific case by case. Like how much should she pay and how much do you not have to pay? We cannot force us to pay. See, we'll see if there's a way to get out of it. At the end, you can tell them. At the end, you can tell them, I only can pay a certain amount, there's nothing more I can pay, there's nothing they can do, but we have to find a way that would work for this. We have to meet the doctors, and sit with the scholars and come up with a formula. Inshallah, from the topics for next conference, what we're recommending is medical issues. But maybe we'll see if we'll pick that topic. That's one of the suggestions. We'll vote on it at the end, as usual. Maybe issues next time related to medical issues. Life, death, life support, and all these things. Many different medical issues that we can discuss. We'll call many of our, we have a lot of fuqaha who are also doctors. We'll have them be discussing. And hopefully we'll be able to come with something that's beneficial for people. But I don't have a fatwa now then for that.
جزاك الله خيرا. الحقيقة ده السؤال الحقيقي اللي أنا جئت له يا شيخ لو سمحت لي يا شيخ أشرف. سؤال آخر يعني. السؤال اللي فضيلة الدكتور معا الحقيقة أنا ذكرت حضرتك أربع صور مختلفة. يعني أنا أحتاج ساعدني في يعني استيضاح هذا. الأربع صور تبين أو
He said you mentioned 4 scenarios that I need to clarify.
على التحريم في 3 منها.
You mentioned
بالأحرى على
that three of these scenarios are haram, 3 of them are halal, 1 of them is haram.
سيئة ذكرت في معظم الحالات لم يكن في كلها. شراء البيت الفوركلوجر.
Buying foreclosure homes, you said it's permissible.
مع
Even though
حتى مع حالة الحكومة
even though
ترفض أن تمنح نفس الفرصة أو التخفيض لصاحب البيت أيضا.
So even though that the house, the bank must pay you a loan. So you said number 1, it's permissible.
ليس مطالبا أن يعرف ما يدور خلف الستار. أنا أمامي بيت عليه فوركلوجر فقلتم بالحلم. ثم تكلمتم بالتوفير واستدركتم على الدكتور صلاح إن جاز التعبير. مسألة أنه لم يرى أخذ الأجرة.
Number 2, he doesn't think that when a person buys commercial real estate and their companies renting out shops doing haram things, you said you don't think there's a problem taking the rent from those shops. And then number 3, you said renting out those places to people of haram, you said it's haram. And to haram, you said it's haram. So you said, but you said, I think all 3 should be halal. Why did you say this? The last one's haram. He thinks that like the last case should be the same. I am giving him a benefit, I'm renting him a benefit, and so he does what I want. Why should I be blameworthy for that? Maybe it could be makruh, and I heard that Sheikh Walid said it's makruh for this. based on working on haram together or something indirectly. But it could be makruh, but I don't think it's haram because at the end of the day I'm just renting him a building. He does what he does with it. So what do you think, Yani?
الحقيقة هو مجموعة من الأسئلة
Sheikh said there are many different questions that are related. So he said we have to separate between different cases. As for the short sales, so I don't know what short sales have to do with this issue. No, he said no, foreclosure. He said, even though this house was taken, even though the house was taken from someone against his force when it's foreclosed, and he forced him to sell, I can still go buy for it. He said, the country, the government will sell a property, obtain the property, and the owner of the property didn't pay his debts. His taxes. So it's taken from him. It was taken from him against his will. And now the county is the owner of the property, and they put it in the market for sale. That's the issue. So me, I want to buy property. It's worth $10,000. The tax note amount. So you mix. It's not. It has nothing to. This isn't about foreclosure. We're talking about buying property that worked for someone who didn't pay his taxes. The government takes it. So the original owner didn't pay it, and he's forced to sell it. So I said, can I go buy that, even though I know he was forced to pay it? Me wanting to buy, I have a building that's being sold for very cheap. Can I buy it? Me? I say yes, because I didn't oppress anyone. I didn't take anyone's house. The government took his house. And it's already in the market for sale. So I just buy it. And so I can pay as much as needed to buy it. That's the first one. The second one, taking the rent of the shops are doing haram. So for me, I didn't see any dalil that would say it's haram. I didn't see any evidence that would make it haram, clear evidence, that this would not be allowed. Sheikh Saab brought some evidences, but they weren't clear to me. For me, I think the evidence that the Sheikh brought are not related to this. He brought cases that aren't related to this issue. So what I think is that since this is a secondary issue, not a primary issue. The primary issue is that you bought the commercial property. The secondary issue is the money coming from what's being rented. So the secondary issue becomes halal when it's included in the primary issue. However, once the lease is up, you should not renew the lease if they're doing haram. Because that's what will be haram, because I agreed that they would continue if I re-signed the lease with them. As for before, it was already going on, it was already leased to them, I wasn't responsible for it, I just bought the property. So that's why this is different than the last case. Because the last case, I was the one who signed the lease with them.
لم يباشر بيع حرام، لم يدخل في بيع حرام. إنما جل ما فيها أنه قد يكون ساعد. So he says, well, why would the last case be haram? All I did was engage in a lease contract. That's it. وأنا أعلم بكل ذلك فكأن نعم
بينهما فرق يعني أما الأولى فقد يعني تملكت الدولة العقار.
He says, what's the difference between the last one and the first one? Why did you say halal for the first case, not halal for the last case? He said there's a difference between them. In the first case, it was the government who took the house. In the last case, I'm the one directly engaging in this. Sheikh Salah said, I want to add a point. When a person buys a house, and part of it's already released out for haram, I should remind everyone that this property that has some part of it that's haram. It could be that its price may have gone up because of the haram in it. And once they get the haram part out, the price will go down. the price of the property will go down. So also just be aware of this. There's a risk that you do take you should take into account when buying such properties that have a part that has haram. Once the haram is done, the lease is over, and you kick him out, the property price will go down, might go down. It was the nightclub or the haram part of the building that brought the price of the property up. Then when you kicked out the nightclub, the price went down. So just be aware of that when you're buying such properties.
وقد وعدته أن أذكر هذا على المنصة والحمد لله أن الله جل وعلا ذكرني به.
We will continue the open discussion, no break, because we already exhausted the time of the break. So we continue, inshallah, with the open discussion. And up to this point, inshallah, I will leave. I think Allah subhanahu wa ta'ala to bless our